You are now tuned into the Black Law Students Association of Canada's YouTube.
And without further ado, I will now cede the floor to our Honourable Justices of the Diversity High Court of Canada, Justice Frank Wallen and Justice Michael Bernstein.
Justice Wallen.
Morning all. Justice Bernstein, Mr. President, judges as usual. Good morning.
Good morning. Justice Wallen, you're the president this morning.
Obliged. Counsel, good day all. When you introduce yourselves, can you speak your name clearly, first and last name? And I have W at the end of respondents. Does that mean Western?
Yes, Justice.
All right, well, we'll get right into it. First off, on the appellant side, are you reserving any time for reply?
Yes, Justice. I'm going to take 20 minutes for myself, 24 for my colleague, and 1 minute for reply.
All right, Justice Bernstein, any questions?
No.
Let's get right at it then, please.
Good morning, Justices. My name is Madeline Stewart, and I'm counsel for the appellant, Mr. Jamal Williams. This is a case about guaranteeing that all Canadians benefit from the full protection of their charter rights. And conversely, it's also a case about ensuring that the executive branch of the state comports with its charter obligations fully and diligently. But it's also a case about Mr. Williams. In a case about differential public health outcomes, we inevitably must talk a lot about statistics, but it's important to not lose sight of the human beings represented by those numbers. Mr. Williams is both a member of a community and he is an individual. And as a Black Canadian man, he carries with him a lifetime of encounters with systemic racism. The COVID-19 pandemic has intensified the pre-existing inequities experienced by racialized Canadians. According to Toronto public health figures from early summer 2020, people identifying as Arab, Middle Eastern, West Asian, Latin American, Southeast Asian, or Black were 6 to 9 times more likely to test positive for COVID than white Torontonians. The gravity of the situation for Mr. Williams and for other racialized Canadians cannot be overemphasized. This court should grant the appeal for 2 reasons. Firstly, the minister's decision to not collect disaggregated race-based data engaged and infringed Mr. Williams's rights to life and security of the person under Section 7 of the Charter. Secondly, the decision created a distinction based on race and perpetuated disadvantage in a way that infringed Mr. Williams's equality rights under Section 15. Neither infringement can be saved under Section 1. We request that this appeal be allowed and the order of the Ontario Court of Appeal reinstated. I'll move on now to the Section 7 issue, and following that, my colleague A. Rafat will speak on Sections 15 and Section 1 in turn. Now, my submissions on Section 7 today come in 3 parts. As a preliminary matter, I'll demonstrate that the minister's decision to collect colorblind pandemic data is precisely the kind of state decision to which Section 7 applies. Secondly, I'll speak to the specific causal relationship between the actions of Canada and the corresponding deprivation to Mr. Williams's life and personal security interests. And third, following this, I'll pivot to the principles of fundamental justice and show that the minister's decision was both arbitrary and grossly disproportionate. I'll draw your attention now to paragraph 8 of the appellant factum. And in discussing the broad contours of exactly which types of state action attract Section 7 scrutiny, I want to emphasize 3 things today. Firstly, the appellant in this case does not seek to impose a positive obligation upon the minister. Mr. Williams's claim is best characterized as a case in which the government has chosen to act, but has failed to do so in a way that is charter compliant. The minister has already chosen to respond comprehensively to the pandemic. More specifically, she has already chosen to exercise powers under Section 4 of the Department of Health Act to collect data for the specific purpose of guiding the government's pandemic response. So Mr. Williams is not demanding that the minister develop a particular policy or begin any sort of freestanding initiative. What he's asking, rather, is that where the minister chooses to exercise her powers, she do so in a manner that respects his constitutional rights along with his personal dignity.
Counsel, in other words, you want this court to second guess what the minister has decided in not collecting race data. She has made a decision, as I understand it, but you want us to go back and say, Minister, you got it wrong.
Justice, that is correct. We assert that the minister has made a decision, that it's reviewable by this court, and that this court should find that that decision infringes both the Section 7 and 15 rights in a way that cannot be justified under Section 1.
Right, but doesn't that have us subordinating or second guessing the legislature? Doesn't that have us acting as the elected officials of government?
Yes, Justice, we acknowledge that the government and the courts have differing roles, and of course they also have differing core competencies. In this case, however, we point out that we're requesting a purely declaratory remedy here. So this requires the court only to make a determination as to whether the appellant's charter rights have been infringed. And this leaves a broad degree of latitude to the minister to determine exactly how she will collect race-based data in a way that's ultimately charter compliant.
So is it your position that the court has the jurisdiction and institutional competence to instruct the minister on exactly what data to collect and what to do with that data? Or is it your position that that remains a policy decision for the minister? And all you're asking is that race-based data be desegregated or be collected.
Correct, Justice. All we're asking is that this court make a determination on the particular facts of this case about whether there has, based on the minister's decision, been a Section 7 and 15 infringement.
And so you're not saying the court has the right to second guess what the government can do with the data, just they should have collected it.
Justice, we hope that once the minister hopefully collects this data, that she will do the right thing and use it in a productive way that recognizes the legacy of systemic racism in Canada and proactively seeks to rectify race-based disparities. It is possible that in the future, if the minister does not act in such a way, that further litigants will come forward, and it may be unconscionable for a future court to allow the minister's ultimate use of the data to go unreviewed. But that is not the case before us today. And as a result, we request that we stick to the specific facts of the case. Now, in the alternative, if this court does choose to recognize this as a positive obligations case, so to speak, we submit that the Supreme Court has explicitly remained open to the possibility that Section 7 rights can be engaged by state inaction. We highlight in particular the comments of former Chief Justice McLaughlin in Gosselin. While a Section 7 right was of course not engaged on the particular facts of that case, the Chief Justice reiterated the words of Lord Sankey in the Edwards case about the Constitution being a living tree capable of growth and expansion. More to the point though, she expressly stated that Section 7 one day may be interpreted as including positive obligations, and went so far as to caution that it would be a mistake to prematurely freeze the development of Section 7 jurisprudence. So in short, even if this court chooses to interpret Mr. Williams's claim as a claim for positive rights, Section 7 will nevertheless be engaged. Now, finally, the political dimensions of this claim do not make it non-justiciable. We point to the comments of Justice Martin in paragraph 9 of the decision below, where she said that the constitutional duty to collect race-based data is only political insofar as the Constitution directs this court to, at times, engage in the inevitably political act of delineating the content of our constitutional rights. Now, the question before this court has a clear legal element, and accordingly, it does not fall into the narrow range of purely political questions that are non-justiciable under Canadian law. I'll point you now to paragraph 16 of the appellant factum. And starting there, we talk about the causal nexus issue. Now, there are two different causal nexuses through which the actions of the Canadian government caused deprivation to Mr. Williams's life and personal security interests. Firstly, the minister's decision had the effect of creating a barrier to life-saving public health interventions for racialized communities. We know from the case law that where the state imposes barriers to accessing appropriate healthcare for life-threatening conditions, the life and personal security interests under Section 7 will frequently be engaged. In PHS, for example, the Minister of Health's decision to not grant a statutory exemption for a safe injection site engaged the Section 7 interests of the site's clients because it prevented them from accessing necessary and indeed potentially life-saving treatment. Now, in this case, the minister has very similarly made a discretionary decision that creates a barrier to life-saving public health interventions. And it creates a barrier because without access to disaggregated race-based data, nobody will be able to effectively implement the kind of life-saving targeted interventions that we need. Both state and
what exactly is the barrier? You say there's a barrier. What's the barrier?
the barrier is created by the state explicitly deciding to not collect the data. Because both state organizations at all different levels of power, as well as non-governmental organizations and even down to community-based grassroots groups, rely ultimately on data at the level and breadth that only the federal minister has the capacity to collect.
But how does that prevent access to healthcare? Like the barrier is access to healthcare, correct?
The barrier is not access to healthcare, Justice, but rather a barrier to the potential to benefit from life-saving public health interventions based on race-based data.
Well, what's the difference between barrier to healthcare and access to that? Is there a difference?
We agree that there are similarities. We see a lot of similarity between this case and PHS. In that case, it was access to a safe injection site. In this case, it's a bit more complex of a causal chain, but ultimately, if the government decides to completely fail to turn its mind to the issue and fails to do the absolute minimum needed to make this data available and these interventions possible, these kinds of interventions simply cannot get off the ground. And as a result, Canadians will continue to die in disproportionate numbers. Now, we point out as well, the government is already deploying the resources necessary to collect vast amounts of pandemic-related data. And the expense required to add a few questions pertaining to race to their existing collection initiatives would be negligible, especially when we consider that lives are at stake here. I'll turn now to paragraph 22 of the appellant factum.
Counsel, before leaving that point, your friends at starting about paragraph 34 of their factum say that you are completely wrong. There is no causal connection between this disparate effect on Blacks and the collection of race data. And they point to a number of things which this point to occupations, they point to discrimination, education, income, wealth gaps, things like that, which you acknowledge at paragraph 17 of your factum. So they say that there is no direct causal link. And in answering Justice Bernstein's question, you talk about a complex causal relationship. Can you point us, take me sort of very directly to the connection that you say collecting this race-based data will have on Mr. Williams, the appellant's life?
Justice Walwyn, I think that I might be best able to address your concern through an example from another jurisdiction where this kind of disaggregated race-based data is collected. So I'll point your attention to an example from California and to a cancer initiative targeting Latino women there. Now, Latino women in the United States experience cervical cancer at much, much higher rates than non-Hispanic white women. By analyzing race-specific data, because that kind of data is available, the team behind this intervention was able to realize that one of the critical points of disparity was at the cancer screening stage. So seizing on this knowledge, that team developed a public health education short film. And in that film, they employed highly culturally specific narratives, which were aimed at increasing screening and vaccination uptake in Mexican-American women in LA County. Now, women who participated in the intervention and viewed the narrative short film showed a significant increase in screening rates. But more to the point, the screening uptake was much higher than in a control group that was exposed to a non-culturally specific video. So this is an example of how disaggregated race-based data successfully improves health outcomes and prevents deaths by taking a preventative approach.
But that's all in one. That's all in one health area, which is cancer screening. What we're talking about are impacts that come from a myriad of different societal directions: housing, income. None of these, many of these are province-related issues and not just federal-related issues. And the Minister of Health will have no impact, no control over that. What we have is people presenting with a problem at wherever, a clinic, a hospital, and they already present with COVID symptoms, or they present because there's a suspicion of that. That has nothing to do with what caused a disparate effect on the race.
If I'm understanding your concern correctly, you're pointing to the fact that there are a great number of social determinants of health.
Which are causing the concern that your client has come to the court with. It's not just the health minister's collection of data. Your factum acknowledges that there are a myriad of causes, as does the other side.
And certainly we acknowledge that to be true. That being said, and I believe my colleague will get into this in greater depth in her portion of the submissions, there is a great amount of evidence in the social science literature suggesting that even when these other non-race specific causal factors like housing, like neighborhood, like socioeconomic status are controlled for, individuals in racialized communities still experience a disparate and a substandard level of health outcomes. And that disparity and the way in which it manifests is different between different racialized communities. So we submit that while the minister simply collecting race-based data is not sufficient to rectify disparities that have long existed in Canada, it's certainly necessary. Now, I'll move quickly through my argument rooted in critical race theory. And I want to submit that this court should find an additional causal nexus between the state's actions and the appellant's deprivation. Beyond the actions of one particular minister at one particular moment in history, this court should also recognize that the Canadian state bears broad responsibility for the racial disparities in health outcomes that have existed long before this pandemic. Now, up until now, the Supreme Court has only applied Section 7 to discrete state actions by a particular legislature or minister or administrative decision maker. But this case presents an opportunity for this court to boldly recognize the role of the state throughout Canadian history in reproducing racial hierarchies that have caused grave harms to racialized Canadians. So we submit that Section 7 should be read as encompassing those violations of life and personal security that have developed more gradually over time as the result of many state actions throughout history. These infringements are no less harmful and they're no less deserving of a remedy. But in order to begin to remedy these historical injustices, the Canadian state must take a race-conscious approach rather than the default colorblind approach embodied by the minister's decision. We simply cannot rely on colorblind solutions to color-bound problems. Now, in the interest of time, I wish to speak to an argument that I believe my friends will raise. Specifically, I think they'll argue that the minister's decision advances other important objectives beyond just the promotion of health. I understand that they'll point to the objective of preventing the exacerbation of racial prejudice and stereotypes, and of preventing the inappropriate use of race-based data for surveillance purposes.
When you say that's beyond the ambit of health, do you not see that mental health, for example, might be impacted by that argument?
Certainly there is scope for mental health to be affected by the minister's decision and by the collection of various types of data.
No, my question was specifically with the argument you're about to respond to. They say it will promote racism, and you say that it's outside of health. And I'm asking whether the Minister of Health is not entitled to address that in response to potential mental health outcomes.
We would submit that broader societal interests, related though they may be to health, are better addressed at the Section 1 analysis, where the justificatory burden switches over to the state. And we would point to the comments of former Chief Justice Lemaire in Swain, who noted that these types of broader interests are better dealt with under that phase of the legal analysis.
All right, we'll let you get back then to responding to the argument.
Mm-hmm. In addition to this, we would point out that the concerns raised by the respondents are vastly outweighed by the heightened threat to the very lives and health of racialized Canadians, which the minister's decision perpetuates. We're talking about the speculative potential for an exacerbation of prejudice compared to a very, very real threat to lives and both short and long-term well-being here. And I see that my time is up. Justices, may I have an indulgence to briefly conclude?
Please, thank you, Mr. Justice Bernstein.
Of course.
Thank you. The COVID virus kills unevenly across Canadian society. It follows the patterns of systemic racism that have been etched into Canadian society over the past 4 centuries. The minister's decision to ignore this reality and to adopt a colorblind data collection approach violates the appellant's Section 7 rights to life and personal security. Subject to any further questions, those are my submissions. And I turn things over now to my colleague, Ms. Rafat.
Justice Bernstein, any questions?
No questions, thank you.
Thank
No
you.
questions from me. Mr. Timer, can I ask you to hold that sign up for me for like a second longer than you do? I just see it flash across my screen, and by the time I focus, it's disappeared. Thank you.
Good morning, Justices. My name is Aya Rafat, and I will present the appellant's submissions under Section 15 of the Charter and Section 1. These submissions can be found starting at paragraph 40 of our factum. The submissions under Section 15 come in 3 parts. First, the minister's decision to collect colorblind data is properly characterized as law under Section 15. Second, in the alternative, that the failure to collect race-based data is framed as inaction, this court, in accordance with critical race theory and our charter, should include state inaction in certain limited circumstances. And third, the minister's decision creates a distinction based on race and perpetuates disadvantage. The minister's decision cannot be saved under Section 1. But before I get into those submissions, I'd like to briefly discuss the causal nexus in this case between the law and its effect. I'll then turn to the legal issues set out at paragraph 41 of our factum and address the issue of whether the minister's conduct infringes on Mr. Williams' Section 15 rights. So to establish the causal nexus in this case, we ask this court to place a lower burden on the claimant and a higher burden on the government, because that's what makes the most sense on these facts. And as noted by legal scholars and Justice Abella and Fraser, it's what makes the most sense in adverse impact discrimination cases more generally. In Fraser, Justice Abella held that evidence of the law's impact is helpful, but not required for the claimant to demonstrate a disproportionate impact. And here, Mr. Williams faces a catch-22, because the very data he would require to demonstrate a disproportionate impact is the data he's asking for in this case. So speculative evidence is all Mr. Williams has. Now, despite this, the link is a reasonable one to draw. It's reasonably foreseeable that if we do nothing to acknowledge and address systemic racism and its inevitable impact in health, disparities in illness and death will persist.
Well, in the context of COVID-19, what exactly are you saying? Like, in practical terms, what are you saying the link is?
In practical terms, the link is that it's reasonably foreseeable, given that we know systemic racism exists in Canada, and the fact that systemic racism, we know it impacts health disparities. The link is reasonably foreseeable that if we do nothing to acknowledge or address these disparities, they will persist and be perpetuated in the COVID context.
What's the link between failure to collect the data and health outcomes?
Failing to collect and acknowledge race-based data prevents Black Canadians from receiving targeted health interventions and educational measures that can directly ameliorate the disparities.
Okay, that's I understand that, but practically speaking, in the context of COVID-19, what are Black men not getting that they should be getting?
They're not getting, so when the minister responds—
What is your client not getting?
Our client is not getting adequate response to COVID and the protection of health of the Canadians in response to COVID. So
For example, what?
So for example, if we collected race-based data and we found that only 10% of Black Canadians relative to their general population were being vaccinated, the minister can then respond through, for example, public health education or creating more vaccination clinics in Black neighborhoods. But without this data, the minister cannot respond to the unique needs of Black Canadians that is perpetuated through systemic disadvantage. Without race-based data, we simply can't respond to these disparities in an adequate and informed manner. What you don't know can and will hurt you.
Thank you.
Thank you. I'll now address the submission that the minister's decision is conduct taken under the authority of law and is properly characterized as law. And this can be found at paragraph 41 of our factum. In taking authority under section 42H of the Department of Health Act to collect colorblind data, the minister's act amounts to adverse impact discrimination under section 15. So the facts of this case are different from Otten, where the majority of the Supreme Court found that the government did not violate the charter by failing to fund therapy for autism. The reasoning for the court in that case was that the legislative scheme guaranteed funding only to core services provided by physicians, and the service of therapist was not guaranteed under law. So the issue in that case was allocation of health funding. In contrast, what we have here is a legislative scheme that gives the minister discretion to collect health-related data to protect the health of Canadians, which she exercised. So this case becomes more like Eldridge in that the primary issue is adverse impact discrimination. And the Supreme Court in Eldridge held that section 15.1 will require the government to take special measures to ensure disadvantaged groups can equally benefit from a government service. If we apply that principle here, it means that section 15.1 requires the minister to collect race-based data to ensure that Black Canadians can equally benefit from her response to COVID. Race-based data is a fundamental and necessary component of targeted public health interventions that can directly ameliorate the unique disparities racialized people like Mr. Williams face from COVID. But in the alternative that this court views the issue as inaction, section 15 is still engaged for two reasons. First, including state inaction is consistent with a proper understanding of our charter and the relationship between the courts and the legislature. And second, that achievement of substantive equality under Section 15 will mandate positive obligations in certain circumstances. I'll address the first point, and that can be found at paragraphs 43 through 44 of our factum. Applying to Section 15 to state inaction would not usurp the role of the minister, or the role of the legislature. Rather, it would serve to fulfill the intent and purpose behind our charter. The majority of the Supreme Court in Vriend held that Section 32(1)(b) of the charter is worded broadly enough to apply to situations where the legislature refuses to exercise their authority. And this is consistent with Section 15 jurisprudence. Under Section 15, the positive-negative distinction is not helpful because substantive equality and Section 15 often deals with under-inclusive measures that fail to, in effect, protect a protected group. So if we look to a case like Vriend, that case was about the omission of sexual orientation in the Individual Rights Protection Act. And the government in that case tried to argue at the Supreme Court that what the claimant was asking for was a positive obligation. But the Supreme Court did not frame it in that way because Section 15, an achievement of substantive equality, will mandate a positive obligation in some circumstances in order to achieve substantive equality for claimants. I'll now address the second critical race standpoint on positive obligations, and those can be found at paragraphs 45 through 49 of our factum. In order to achieve substantive equality and its broad protection of systemic disadvantage, courts should include a positive obligation in this case to accommodate for the discrete and invisible ways in which racism continues to impose barriers to the achievement of health and equality for racialized Canadians.
Counsel, that's with respect to health writ large, correct? Like presenting to a hospital with respect to any condition. Am I correct in that?
Our critical race theory acknowledges that because of the realities of systemic racism, courts should not close the doors on positive obligations, particularly under Section 15, where the focus is substantive equality. However, the
Counsel, my question is specific to this view that you just expressed, that when you get to a hospital, there is racism in the process. Is that what I'm taking? Am I taking away correctly from what you just said?
Yes, Justice. Our focus is both preemptive and preventing Black Canadians from being infected by COVID, but also what happens once they're in the hospital and how unintentional bias and discrimination by medical personnel can also impact health disparities. And
is there any evidence that the appellant, if presenting with COVID or with COVID symptoms at a hospital, will experience racism or has experienced racism?
We don't have particular evidence towards COVID. However, there is evidence that medical personnel often portray unintentional discrimination by failing to acknowledge or assuming difference, that where difference is not appropriate. And in medical schools, for example, assumptions that Black people are
Right, so that evidence exists. It can be addressed. We don't need to go and have people collecting race-based data, disaggregated or not, to address that. We already know that.
Absolutely, Justice. We know it. However, without data, we can't respond to it in an informed way. We can only respond through assumptions. And especially in a time like COVID, data has informed our entire movement. So for example, when cities should go on lockdown, that's being responded by data. Without data and collecting that, we wouldn't be able to know when we should go on lockdown. Assumptions would be made. However, if the minister decides to respond, she would need data to respond in an informed manner, and also to see whether the interventions are actually effective. So by comparing whether disparities are increasing or decreasing. Without that, without data, we can't be able to tell whether anything is actually working. I'll turn now to the first step of the Section 15 analysis, proceeding at paragraphs 50 through 55 of our factum. The collection of colorblind data creates a distinction under Section 15 on the basis of race. The minister's act adversely impacts Mr. Williams and violates our charter norms of substantive equality. So adverse impact discrimination happens when a neutral law or practice has a disproportionate impact in effect on members of a protected group. And this fails to achieve substantive equality under Section 15. And here, despite this facially neutral act by the minister, the reality for Black Canadians is the perpetuation of health disparity for COVID. In the phrasing of Justice Abella and Fraser, the statistical disparities here are a compelling sign that the minister has not responded in a way that takes into account the circumstances of Black Canadians. The United Nations has repeatedly expressed serious concern about Canada's treatment toward Black Canadians, and in particular has noted their health disparities. And supporting this is regional data of the COVID disparities in Canada. For example, if we look to Toronto, Ontario, and public health collection of race-based data, we see that 83% of reported COVID cases are by racialized Canadians. That's 83%.
Don't we have the highest level of multiculturalization in any city, for example? And Canada is recognized as being multicultural. Why is it so surprising that 83% are from racialized communities?
Absolutely, Justice. We do have a multicultural background. However, we do note that even when it's compared to white people and controlled for those issues, disparities still exist. So for example, going to the example my colleague referenced, research consistently shows that whether a Black person is at the lower end of the class spectrum or at the higher end of the class spectrum, relative to white people in that class, they continue to face disparities. And we also know that systemic racism exists in Canada. And we know that that impacts health disparities. And so from a critical race standpoint, this court has the opportunity to address a systemic issue. And that is particularly exactly what Justice Abella envisioned in Fraser when she broadened our understanding of substantive equality in order to account for systemic and discrimination at the systemic and institutional level.
So what data are you actually, in particular, are you asking for?
We're requesting for disaggregated race-based data. So for example, we note that Statistics Canada has collected data, aggregated data based off of neighborhoods with visible minorities. And that data has found that neighborhoods with 20% or more visible minorities are twice as likely. So we're asking for briefly, just as we're asking for disaggregated race-based data that
so
would.
Like, what do you want the boxes to say? What is disaggregated race-based data?
So in contrast to something that would say visible minorities, we would like something that says, for example, Black, Arab, Latino, specific.
And it's actually quite a long list. It is over a dozen. There would be a dozen boxes on that list, right?
Yes, Justice, because of the multicultural nature of Canada.
And the particular racialized groups in that list are not, they're not entirely the same. And they're the subject of different challenges, right?
Absolutely, absolutely, Justice. There would be a long list. However, we note that this collection of data would not be particularly difficult for the minister, as we note that Toronto, Ontario, Peel Region, Manitoba has already been collecting this data. Further, higher institutions like law schools annually collect this data and publish it at a regular basis. And so this would not be an onerous obligation on the minister to do.
We stop the clock for just a second while I ask the time or something. How do we take account for the time that's reserved on the appellant side for reply? Do you indicate that in your flashes? Okay, thank you. Continue, counsel.
Thank you, Justice. Turning to the second step of the section 15.1 analysis, and that can be found at paragraphs 56 through 68 of our factum. Where an act contributes or worsens a group's already disadvantaged position, this is sufficient under the second step of section 15 to establish the necessary connection. And here, the minister's failure to collect race-based data both worsens and contributes to the disadvantaged position of Mr. Williams for two reasons. One, it exacerbates the pre-existing disadvantage he faces in healthcare by failing to give rise to the data that can bring about evidence-based response and targeted public health initiatives that ameliorate disparities. And second, it prevents an informed and educated Canadian community that can dispel stereotypes and biases that harm or racialized Canadians like Mr. Williams. I'll briefly turn to the second point related to stereotyping in the interest of time, and that can be found at paragraph 65 of our factum. Ignorance, and specifically withholding data and the opportunities for education, perpetuates apathy, which leads to stereotypes and misinformation. Hate crimes and unintentional discrimination may persist and harm Black Canadians in and out of healthcare without data and educating the Canadian community. For example, at the onset of the pandemic, information was being circulated that Black people could not contract COVID. Not providing information and data can actually harm Black Canadians more. The government can easily respond to stereotyping and should respond to stereotyping through education and protect the disparate deaths of Black Canadians at the same time. This should not infringe on the realization of Mr. Williams' constitutional rights and ultimately his health. With the balance of our time, I'd like to address our arguments under section 1, and those can be found at paragraphs 71 through 74 of our factum. I'll move straight to the proportionality prong. The minister's failure to collect race-based data does not achieve the protection of Canadians in a real and substantial manner. In fact, it does the exact opposite. A law that fails to protect Black Canadians from Canada's response to COVID cannot be said to be minimally impairing. All Mr. Williams is asking for here is for the government to add an extra category of race on the data that is already being collected. This is an extremely simple task for the government to take on, and yet its omission perpetuates the disparities in illness and death for Black Canadians. In a case where the racialized identity alone of Mr. Williams means he may inevitably be at a disparate risk from COVID, the case before this court, the charter, and you justices is one of life and death.
Just before we go there, I was just thinking, you're asking for a declaration that the existing data collection protocol violates the charter. Are you suggesting that there should be a mandatory, it should be mandatory race-based collection of data, that people should be ordered or required by law to provide race-based data?
Justice, our focus is just on COVID right now. We're not asking.
No, I mean, as far as COVID is concerned, that people are obliged by law, are compelled to identify, to complete the questions that are related to race-based data.
Our focus is just on the minister in this occasion. We're not asking for all provinces and regions.
No, I'm just talking about the minister. My question is, do you want the government, the minister, to compel this data? Is it going to be voluntary or compelled? Are you going to require by law people to identify themselves on the basis of their race for COVID-19 purposes?
I see, Justice. If I understand your question correctly, it's the focus of your question is on Canadians and whether they would be complied to answer this on a questionnaire, for example.
Right. That's right.
Okay.
Like, is it optional or mandatory?
If I could just ask for a brief indulgence to answer and conclude.
Yes, of course.
We would encourage it to be optional. However, our focus is not on telling the minister how she should do her job. So that would ultimately be left up to her. But we would give discretion to the minister and also encourage it to be optional in case individuals prefer not to disclose that information. The simple solution to the sections 7 and 15 charter breaches for Mr. Williams and the risk of death at stake should be granted through a declaration that the minister's conduct infringes sections 7 and 15. Sections 7 and 15 protections would be illusory if we did not ensure them at such a critical moment in time. Subject to further questions, those are my submissions. Thank you.
Justice Bernstein?
No more questions, thanks.
Thank you, counsel. Yes, counsel, please start.
Good morning, Justices. My name is Clay Fernandez, and together with my co-counsel Lauren Harvey, we'll be representing the respondent, the Minister of Health, in this appeal. Justices, this is not a case of the respondent fueling systemic racism in Canada, nor is it a case of them ignoring it. It is one in which the appellant seeks to fetter the discretion of the minister through the Canadian courts at a time where Canada needs us to rely on the advice of the medical experts, as well as creating an urgent response through the minister. You will see throughout the respondent's submissions that we should not allow this appeal for a number of reasons. First, I will address our theory-based argument, which speaks to the risk that this data has towards Black Canadians, as well as to the minister's objectives. Then I will address why the Supreme Court did not err in finding that Section 7 of the Charter was not violated. My co-counsel will then address why it would be inappropriate to impose a positive obligation on the respondent. She will then address how the Supreme Court did not err in finding that Section 15 of the Charter was not violated. And finally, she will demonstrate that following the principles set in Doré and Loyola, an administrative law review is more appropriate than a Section 1 Oaks analysis. In the face of an emergency whose scale has not been seen by this generation, the Canadian courts and people must allow the medical experts to guide our response. By allowing the minister to respond in the current manner, an effective and efficient distribution of limited resources is achieved. As such, the respondent respectfully submits that this honorable court dismiss the appeal and uphold the order of the Supreme Court of Canada. Justices, I would like to first direct your attention to paragraph 20 of the respondent's factum, where I will make submissions on our theory argument related to the risks data poses towards further stigmatizing Black Canadians, as well as towards the minister's objectives. In order to understand the potential risks that this disaggregated data collection poses, we must first look to some of the research of Dr. Shelley Reuter and her discussion of disease concept. Dr. Reuter identifies that ideation of a particular disease as being targeted towards a singular group is a dangerous and sinister metaphor used to the detriment of that group in order to other them. Applying this now in the context of COVID-19, we can look to the experience of Asian Canadians across the country who have seen a rise in racist incidents since the onset of COVID-19. Taking this now in the context of the experience of Black Canadians, it is not a leap of the imagination to see that if disaggregated data were to reveal that Black Canadians are disproportionately affected, that they could be subject to the deployment of a disease concept in COVID-19 to their detriment, which would further stigmatize them, as well as support misinformation about the virus. In fact, our friends have even demonstrated and suggested that Black Canadians have already experienced racist events stemming from COVID-19. And so further data which could support this is not of use to the minister. Furthermore,
Council, they're not going to use the data to perpetuate, to propel this racism into the society. They're using it to help prevent some of the systemic causes, effects of racism on Blacks that result in them presenting more frequently with COVID and it being more fatal in their cases. Why would the minister avoid that?
Yes, Justice. Of course, the data may serve a purpose in terms of the minister's response. However, it is important to recognize the risks that the data also poses towards further stigmatizing an already historically disadvantaged group.
Yeah, but you said that, Council, you said that's happening already. You said that your friends concede that. You concede it. So if it's happening, why not do something, collect the data and fix it?
Well, Justice, it's not necessary to collect the data, and we will demonstrate throughout our submissions that the minister is able to meet the unique needs of Black Canadians through their current response, rather than subject them to the increased risks of further stigmatization through the collection of this disaggregated race-based data. Justices, I would also like to take a brief moment to highlight some of the concerns that data collection brings to bear. Our friends suggest that the expense of collecting this data is only minor, as we were only checking a few boxes. While this may be true in the sense that at the point of intake, either at testing centers or at hospitals, a nurse or doctor would be only asking an additional question during the intake. However, this is an additional question that occurs across the country. To date, there's been over 21 million tests for COVID-19. That's 21 million seconds. And it is not only just the collection of the data, which is time consuming, but also the management of the data in order to ensure it's appropriately protected, as well as the analysis of the data, both of which are costly in terms of time, as well as government resources, which could be more effectively spent in addressing directly factors which aggravate risk for racialized minorities and Black Canadians, as well as focusing on providing resources to Canadians across the country so that they are appropriately able to protect themselves and their family.
Council, if you don't ask the question, you're not going to know that you're protecting racialized or Black Canadians. How are you going to know that? And how can possibly ticking a box to say Black, Latina, Arab, whatever, how can that possibly be a concern that the minister looked at and said, no, that time spent is not going to assist this particular racialized group?
With respect to the disaggregated data, our friends present the Black community as an amorphous group who share the same characteristics, as well as the same experiences and the same risks. I would like to delve into a hypothetical example to identify the differences within the Black community. A hypothetical Black man who is making 6 figures and is surviving the pandemic at their second home in Muskoka certainly does not face the same risks that a young Black Canadian who lives in Scarborough and works in a gas station would. The minister is able to respond to the unique needs within the Black community by targeting subsects within it that are most vulnerable. This includes the elderly, and I would like to cite a specific set of data which is up to date as of February 4th. Currently, 89% of COVID-19 deaths occur in individuals who are 70 plus in Canada. That is clearly where the significant issue lies.
How many of those were Black or racialized? Can the minister tell us that?
While we can't answer whether the makeup of that population is Black, Asian, Latino, or any other.
How are you going to address questions then that are specific to them for health remedies?
The minister is pouring resources into the specific communities, which include the Black community and the subsects within it, in order to ensure that those vulnerable groups within the Black community receive the resources we need. To speak further to just the elderly, the minister has focused on pouring resources into our long-term care homes to ensure support workers are able to adequately support their patients and individuals living there, as well as the Canadian Army even being called into long-term care homes. Furthermore, the government has prioritized vaccination of elderly individuals. And it is in these manners in which the minister is able to meet the needs of elderly Black Canadians who certainly may make up a proportion of the group which bears the most significant risk of death as a result of COVID-19. Justices, I would now like to turn your attention.
Hold, counsel, just a moment. I think Justice Bernstein is on mute.
Oh, apologies, Justice.
Justice Bernstein, you're still on mute.
Just so that I have your position, are you saying that there's no utility, there's no benefit to collect this data, or is it your position that the potential harm respecting the use which could be made of this data outweighs whatever benefit may flow from its collection? Because there's a difference. Would you agree that there's a difference between collecting it and issues respecting the improper use or dissemination of the data? So I just want to clearly understand your position.
Yes, Justice. To answer the second half of your question first, I think there is distinctions between collecting data as well as disseminating and responding to it. However, we believe that the collection of disaggregated data is not necessary in order to respond to the unique needs of Black Canadians, and that through the minister's multifaceted response, we're able to respond not just to treating Black Canadians as an amorphous group that has the same experiences, but target the unique vulnerabilities within the Black community in order to effectively allocate resources, which I would remind the court are quite limited, and it is in a pressing and urgent time, so that the minister must respond in a manner which reflects the gravity of the situation, as well as the need for a swift and urgent response.
Okay, so you're basically saying you recognize that there are vulnerabilities, but the government has chosen to respond to those vulnerabilities in different ways, and they have a right to make policy decisions within a spectrum of reasonableness, right?
That is exactly correct, Justice. The minister made a reasonable decision when contending with the different factors presented by competing stakeholders, as well as communities, as well as recognizing our advice of our medical experts and contending with limited resources, which need to meet the needs of Canadians across the country, and particularly Canadians who are most vulnerable to the disease or to the virus.
Thank you.
Justices, I would now like to turn your attention to paragraph 34 of the respondent's factum, where I'll begin to address our Section 7 argument. Section 7 includes the rights to life, liberty, and security of the person. I would like to start by addressing specifically the right to life. In Carter in Canada, the right to life is engaged where a law or state action imposes death or an increased risk of death on a person, either directly or indirectly. We can look to cases such as Chowley in Quebec, as well as PHS and Community Services in Canada, in order to demonstrate the application of these types of Section 7 claims. The common thread among these cases is that a government action inhibited access to health resources, which had the effect of increasing the risk of death. Our friends would like to lead the court to believe that Black Canadians, as a result of the failure to collect disaggregated data, have lost out on the opportunity for targeted interventions. However, we would like to aptly frame the minister's response to demonstrate that Black Canadians have indeed been beneficiaries of targeted interventions. Black Canadians may suffer disproportionately in the context of socioeconomic factors, which we discuss under the social determinants of health. Black Canadians and racialized minorities disproportionately find themselves on the lower end of the socioeconomic ladder. And the effects of the social determinants of health arising from this experience mean that these racialized minorities may experience an aggravation of risk in terms of the risk of contracting COVID-19. Now, the minister has aptly and directly responded to these needs through the financial supports that they have developed through the Canada Recovery Benefit, as well as the Canada Recovery Caregiving Benefit, which puts resources into the hands of impecunious individuals who have contracted COVID-19 or whose dependents have contracted COVID-19 to ensure that they can adequately find resources and the support that they need in order to survive the pandemic.
Counsel, isn't your friend's point that a health resource is information and data, and that these racialized groups are being denied that health resource? Like, that's the resource they're looking for. And that resource is available for aged Canadians. It's available for other groups.
While we can frame race-based data as a health resource, it is still yet to be made clear what benefit this particular set of data actually has. Returning to a discussion that we have in the Respondents Factor regarding statements made by the CDC and World Health Organization, we can see that race is not a primary factor in driving transmission and contraction of COVID-19, but rather it is the confluence of factors known as the social determinants of health, which lead to an aggravation of risk. So while there may be a minimal, if any, value in this race-based data due to the fact that it only speaks to a limited aspect of the experiences of Black Canadians and racialized minorities, we can look to broader aspects of that experience in order to assess whether or not the minister has appropriately responded to them. And it is in this instance we submit that the respondent, through their financial supports, among other multifaceted aspects of their response, have been able to meet, identify, and address the needs of racialized minorities, and in this instance, Black Canadians. Furthermore, I would like to speak to and identify how the government has gone to great lengths to facilitate access to healthcare resources. At the end of the day, data is an intermediary step. Data alone cannot save lives, but rather it is the actions taken through vaccinations, as well as testing centers, and most importantly, our doctors, nurses, and service workers who provide the necessary care and advice to individuals who have contracted the virus that in fact saves their lives. And it is
also, what about the information you disseminate, to promulgate, the minister promulgates to the world at large about how to prevent the disease, about the steps that they should take to avoid contracting it, not just addressing it once they've got it? Isn't that a huge part of this problem and what the minister does?
Justice, absolutely. I was speaking to some of the reactive measures that the minister has put in place, but can also address the preventative measures which have also been put in place. Specifically, geographic-based data and the COVID-19 Tracker app help individuals and their families understand when they have potentially been exposed to the virus, as well as the unique risk levels experienced in certain communities.
Right, but why don't you just address specifically the appellant's concern that this information, this data would assist in preventative measures being taken?
We do not believe that this race-based data will meaningfully support preventative measures. because the government has already taken steps to identify the most relevant factors which address risk of contraction of the virus, as well as continually and ongoing disseminated information to the public about how to educate themselves of the risks of COVID-19, as well as the arguably preventative step of testing centers, which allow individuals to see if they have, in as little as 24 hours, whether or not they've contracted the virus, and then be able to appropriately respond rather than subject themselves, their family members, and co-workers to potential exposure to that virus. So in that sense, while our friends would contend that this disaggregated race-based data may serve a health benefit, the minister is able to meet the health benefit needs in the preventative sense for Black Canadians through the current response, which addresses both geographical risk, spread, all of which are specific to the experience and location of individuals. Justices, I would like to turn your attention to paragraph 46 of the Respondents' Factum, where I'll now address our arguments on security of the person and why that right has not been engaged. We can look to cases such as Morgenthaler and Shaoli, which found deprivations to security of the person on the basis that physical and psychological effects were directly connected to a loss of control over fundamental health decisions and was caused by a state action or legislation. Through the minister's response, they have put control into the hands of Canadians across the country, into the hands of the appellant, and into the hands of Black Canadians. As I've already discussed, we can look to the number of different approaches they've taken in order to facilitate this control over fundamental health decisions. But before doing that, I would like to just briefly turn to Morgenthaler to identify what it means to actually lose control over a fundamental health decision. Morgenthaler is a case in which went to the Supreme Court and was related to a woman's right to abortion. In this case, the government prevented access to the right to abortion and through abortion clinics, which deprived women of the right to make a fundamental health choice about whether or not they would like to carry a pregnancy to term. And the effect of this deprivation was that it could lead to physical effects stemming from carrying a pregnancy, as well as psychological effects as a result of a woman's role in bringing a pregnancy to term, both of which infringe on Section 7 rights under security of the person. So this was a fundamental health decision related to women in the case of Morgenthaler. In the case at hand, there are no fundamental health decisions being taken away from Black Canadians or from the appellant. Through the outpouring of resources made by the minister, Canadians across the country are given the opportunity as well as the resources in order to adequately decide what risks they wish to engage with and how to limit their exposure to COVID-19.
Counsel, just on that point, if I'm a member of the broader community and the minister is concerned about my well-being, and my well-being is looking at a risk that presents, and if in fact the race-based data shows that there's a higher prevalence or a higher incident rate of COVID-19, either geographically where there are lots of racialized people or in pockets of racialized people, would it not be to the benefit of the greater population to promulgate that so I can move myself from that, look at that risk and protect myself from it, self-isolate if you want to call it that?
We could certainly speculate on the value of the data. However,
no, speaking specifically to these risks that you said the minister is promulgating and allowing Canadians to recognize and react to, this race-based data would allow us to know if, yes or no. It may show that there's no prevalence of COVID-19 in these racialized groups, or it may not. But why wouldn't she just have them tick that box so we can know that? So I, as the greater in the general population, can protect myself.
While identifying as many variables and risk factors relevant to COVID-19 is a pertinent step in the process to preventing the furtherance of COVID-19 within Canada, it must be recognized that the minister contends with limited resources and an urgent situation.
Counsel, you already have identified that the minister looked at this and said, oh no, she's protecting racialized groups from stereotyping. So she's already put a mind to that. I'm not saying measure the length of the index finger. I'm saying tick a box saying race.
Yes, Justice. While the framing would make it seem that this specific type of data collection would not be onerous on the government, I would like to identify a few steps that are involved in this actual data collection and why it would be an expensive aspect for the government in order to address. The data collection not only involves asking questions, but also collecting and managing the data, analyzing it, and potentially implementing decisions arising from it, all of which add cost to the government's response and take away resources from parts of the response which would actually provide care, support, and resources to Canadians in order to address their needs, risks, concerns, and contractions.
Counsel, you heard your friends on the other side say that that's not what they were asking this court to do. All they wanted this court to do was say, collect it. What the minister does with it after the fact is the minister's decision. So they're not asking us to order that she spend resources in this sort of convoluted analysis that you're talking about now. I'd really like to hear your comments, your response to that point by your friends that says they hope the minister will use it productively. Like, do you think that's the kind of relief this court should be granting, declaratory relief this court should be granting on a hope?
I do not think that this court should be granting a declaratory relief on the basis of hope. The minister is able to identify the unique vulnerabilities within the Black community through the current response and without the use of race-based data. Specifically, the vulnerable communities are ones who are on the lower end of the socioeconomic ladder. And returning to my earlier discussion about social determinants of health and how those play into risk aggravation, as well as the elderly, who I would like to remind this court make up 89% of COVID-19 deaths. So without this data, the minister is still able to identify and respond to the unique vulnerabilities within the Black community. Justices, seeing as I am running out of time, I would just like to very briefly address the principles of fundamental justice. If this court chooses to find an infringement on the appellant Section 7 rights, this infringement should certainly be in accordance with the principles of fundamental justice. Arbitrariness asks whether a deprivation bears connection to a law's purpose. And while the data claim may serve a purpose, it does not mean that the decision was arbitrary, as the minister's response facilitates access to the most pressing needs. Justices, I see that I'm running out of time. Could I ask for a brief indulgence to complete my submission on principles of fundamental justice?
Justice Bernstein.
At your discretion, President.
Thank you. Absolutely. Please, counsel, continue and terminate.
Thank you, Justice. To conclude, perfection is not expected in a pandemic, nor is it required by law. The minister has made the reasonable decision, which targets unique vulnerabilities within the Black community rather than treat them as an amorphous group who shares the same risks. And it is in this manner that the minister's multifaceted response is able to speak to a wide range of risks and needs across the Black community and the Canadian community as a whole. As a result, the decision cannot be found to be arbitrary. Barring any further questions, Justices, I will now defer to my co-counsel to complete the respondent submissions.
Thank you.
Thank you.
Good morning, Justices. My name is Lauren Harvey, and I will be addressing the respondents' final 3 submissions on this appeal. First, I will address why this would not be an appropriate circumstance to impose a positive obligation. Then I will address that the Supreme Court of Canada was correct in finding that Section 15 of the Charter has not been violated. And finally, how if this court does find that a Charter violation has occurred, that under an administrative law Dore approach, the minister's decision was reasonable and as such should be upheld. Justices, if I may begin by addressing our argument with respect to positive versus negative rights, which can be found beginning at paragraph 12 of the Respondents' Factum. Our friends have suggested that if this court should order the minister to change her approach to data collection by adding an additional data set, that would not amount to a positive obligation, and in the alternative, to nevertheless impose such an obligation. However, since the Charter's inception, it has been interpreted as a negative rights document, which means that it works to protect individuals from unreasonable governmental interference with their rights, rather than to force the government to provide certain services. It is in this way that if this court should find that the minister is to collect an additional data set, that it would be amounting to a positive obligation as compared to protecting a negative right of Black Canadians.
Well, isn't the minister already collecting data? And isn't the issue really, look, you're already collecting data, just collect a little more?
Correct, Justice Bernstein, the minister is already collecting data. However, courts have been clear that one of the reasons in which they have been hesitant to order positive obligations is as a result of the deference that is owed to, in this case, the minister, but in more general terms, the legislature, in making these important choices, as they are in a better position to balance competing interests. And as our friends have acknowledged, and we do not dispute, the court in Gosselin has left open the possibility to order positive obligations, especially in Section 7 cases. It is our position that this would not be an appropriate situation to expand that charter protection to positive obligations for two reasons. Firstly, because the data will provide only minimal value and will not alleviate the disproportionate effects that Black Canadians experience.
How do we know that, counsel?
We know based on data from the CDC, firstly, that there is only a tenuous link between race and transmission of the virus. And so it's unclear what ordering this positive obligation would achieve. If there's no link between race and transmission, collecting this data would not get to the heart of what we are here today to discuss, which is the importance of saving Black lives.
But isn't your friend's point the fact that because we don't have the data, we cannot show these things, and that, you know, just ticking the box will permit us to get this data and address the issue?
I believe that was our friend's point, and I will address the issue of a reallocation of resources eventually in a moment, Justice. But the primary reason why ordering a positive obligation would not be appropriate is because we don't know what this data will really show us, because there's no link between race and transmission. And as has been addressed by our friends, and we agree with them, that as per the Personal Health Information Protection Act at Section 29, which allows individuals to refrain from disclosing personal information, and our friends have stated that this initiative would have to be on an optional basis. It is for this reason that would also detract from the value of the data, because we'd be faced with a limited data set, as Canadians have the ability to opt out of providing this information. And this adds to our concern about the value of this data.
Right. I take your point about the positive obligation and your response to Justice Bernstein. I'm more interested in the argument that they make that this has adverse effect, it's adverse effect racism, adverse impact on a racialized group because the minister did not include that question.
Yes, Justice. If I may then direct the court's attention to our Section 15 charter argument, which can be found beginning at paragraph 57 of the Respondents' Factum. While we do not dispute that Black Canadians may experience disproportionate effects as a result of COVID-19, the minister's approach does not draw a distinction based on the enumerated ground of race. And even if this court should find that it does, it did not do so in a way which perpetuated or exacerbates their disadvantage. Our friends have failed to prove that there was either a benefit denied or a burden imposed on Black Canadians. The benefit which arises out of the minister's current approach is in ensuring that only medically relevant data is disseminated to the public. And this allows for individuals to make informed, individualistic health choices in order to protect themselves.
Can I just ask you a question? You made a very compelling submission earlier that basically you refer to a study that indicated that there was very little evidence of a causal link between race and COVID-19. And that you're used that study to argue, why it does not serve any particular purpose to collect this data because there's no causal relationship. And the argument is, well, maybe if you collected the data, you'd see that there was a causal relationship. Isn't it a catch-22?
Justice, the study that we have relied upon, as my co-counsel stated, and you have alluded to as well, was data collected by the CDC in the United States, where there was disaggregated race-based data collected. And I believe our friends have also alluded to this point. However, after the collection of that data, the CDC has remained firm in their position that there is no link between race and transmission of the virus. And in this way, the minister has focused her resources and approach based on giving deference to the advice of medical experts. And it is for this reason that we say there has not been a benefit given to other groups that was not also given to Black Canadians, because there has been no link between race and the transmission of the virus. And so has there been a link? When you say transmission, does that also encompass contracting the virus? Correct, Justice. I should have clarified, that would include transmission and contraction of the virus. But then how then do you explain the disparate or disproportionate number of racialized persons presenting with COVID? We would contend that the disproportionate effect Black Canadians may be experiencing with COVID-19, while we do not dispute that it may be happening, it is more of a result of the social determinants of health rather than their race. And it is in this sense that the minister has chosen to focus her efforts and her approach on addressing those social determinants of health, which, as my co-counsel has outlined, will also in turn address the specific vulnerabilities of the Black community in Canada. Our friends additionally have not proven that there has been a burden placed solely on the Black community because of this, again, tenuous link between race and transmission and contraction of the virus. Rather, it is more appropriately linked to the social determinants of health, including where an individual may work, where they live, and social supports. Collecting this data may confirm a problem that we already know exists, but it will not alleviate the disproportionate effects that Black Canadians are experiencing. And it is in this way that there has not been a burden imposed solely on Black Canadians by failing to collect this data. While it is our position that there has, for this reason, not been a distinction on the enumerated ground of race, if this court should find that there has been a distinction drawn, it was not done in a way which perpetuated or exacerbated a disadvantage. And our submissions on this issue, Justices, can be found beginning at paragraph 65 of the Respondents' Factum. You're taking us to these paragraphs of your factum. I must say that I looked in vain to find paragraph 39. It just seems to have been misplaced. Is there someplace you've hidden it? Justice, I apologize. In our drafting, we seem to have misplaced paragraph 39. However, the paragraphs that I'm directing you to are the correct versions based on the factum that you have in front of you. I apologize for the confusion. Thank you, counsel. A distinction, if it is found, which corresponds with the needs and circumstances of the claimant group, is less likely to be discriminatory. Our friends have suggested that the minister's current approach fails to appropriately account for the unique needs and circumstances of Black Canadians. However, we do not agree with this characterization. The minister's approach, which was based on an acknowledgement of the risk that the collection of this data could pose, in addition to addressing the unique vulnerabilities of Black Canadians, which she is able to do without race-based data, does appropriately account for the unique situations of Black Canadians. An approach which respects the dignity of Black Canadians is one which acknowledges the hardships that this community has faced and refusing to create situations which would perpetuate that disadvantage. It is in this way, as my co-counsel has outlined, that the minister can address the unique needs of Black Canadians. For example, the financial aid system, which is an important tenet of the minister, or an important facet of the minister's response, is not given to every Canadian. Rather, it is given to Canadians who have been particularly disadvantaged financially by the pandemic. And the minister acknowledges that individuals in Canada certainly experience the effects of COVID-19 at different proportionate rates. And it is in this way that her approach has been tailored to targeting those who unfortunately are the most vulnerable in our society by looking at perhaps where they may work, where they may live, and how they have been individually impacted by COVID-19, such as if they've lost their job or have been forced to leave their job as a result of health issues. Finally, Justices, I'd like to briefly address why the nature of the interest in this case supports that there was not a distinction drawn in a discriminatory way. The minister's approach does not prevent Canadians from seeking medical care or support, as my co-counsel has outlined in his Section 7 submissions. While our friends contended that Black Canadians do not get the full benefit of the minister's approach, we again do not agree with their characterization on this point. As I just mentioned, the minister's approach is multifaceted, which has included implementing various testing sites, pouring resources into hospitals to ensure that they are staffed and resourced efficiently, and creating a financial aid system which can support Canadians. All three of these main facets of the minister's response do not distinguish or are not given only to individuals on the basis of their race. And it is in this way that we do not agree with our friends' contention that Black Canadians have not been able to benefit from the minister's approach. In fact, the particularly vulnerable in our society do get to benefit from the minister's approach in the way that she is allocating these resources.
Well, do we actually know that? Can you point to any sort of evidence on the record to support that submission?
For example, the CRB, which the Canadian government has implemented as their financial aid system, has worked to particularly address the needs of those who have been disproportionately impacted by COVID-19 for various reasons. And so that is the specific example that I would provide to you, Justice, for a way in which the minister has been able to address the most vulnerable in our society.
But we don't know in terms of whether racialized people are receiving the same quality of care as the rest of the population. We don't really know that. You know, you've spoken about the allocation of resources to long-term, to a variety of things, but we don't actually know whether racialized people are receiving the same level of care, do we?
Well, we agree that maybe.
And if we had collected data that indicated the number of people who contract COVID-19, but also, their recovery rates and the number of deaths, we would actually have more information on how racialized people are faring.
With respect, Justice, I would have to disagree in the sense that if this court ordered that the minister collect race-based data, the only thing that we would know out of that data, if I may offer the court a hypothetical in this situation, is if person A attends a hospital, is tested for COVID and treats and tests positive, and they are a Black Canadian, versus person B who attends a hospital, tests negative, and is a white Canadian. As such,
no, you could track, what if they collected data on how long they were in the hospital, what kind of treatments they received, how many of them died, how many were put on ventilators, how many of them were stuck in halls for weeks on end. We would have some data, wouldn't we?
Justice, with respect, it's our understanding that the scope of this appeal was the appellants asking for specifically race-based data at the point of testing in order to determine the race of an individual and whether they subsequently tested positive or negative for COVID-19.
Isn't that's a bit simplistic? I mean, you give your health card number, all of that data, then every step of the medical process after that is linked to your health card information. And you can tease out that information as to what subsequent care was given. Jesus, we need it for contact tracing. We need it for everything. It's not just you tick off race and this person presented as Black and this person presented as Latina.
Given that the minister has acknowledged that there may be disproportionate effects of COVID-19, it is our position that rather than the intermediary step of collecting, storing, protecting, and disseminating race-based data, the minister's resources are more appropriately put towards, as you have suggested, justices, specifically addressing those specific healthcare needs of Black Canadians and those who are the most vulnerable in our society. And it is for this reason that we ask for this court to provide deference to the minister in order to make those decisions, in order to appropriately allocate the limited resources that she has been faced with in this time of the pandemic.
What is the practical harm of gathering the data apart from the stereotyping straw horse, if I'll call it that, pejoratively, that you've raised? What is the practical harm?
The practical harm of data collection, our friends have suggested that it may only be an additional few boxes to tick off. However, as my co-counsel has suggested, there have been 21 million tests performed. And so this is 21 million extra seconds that would have to be allocated at the point of—
Yeah, no, but practically on this, on Canadian society, forget about the second that it takes. What's the practical harm in the minister saying, tick the box?
The practical harm in allocating resources towards, as you mentioned, taking the box or collecting race-based data and presumably storing it, ensuring it's protected, and then disseminating it in order for the minister to make use of it, is that these would be resources that would be better allocated towards the frontline fight, most specifically, by putting the resources into hospitals to ensure that they are staffed and resourced efficiently, and secondary towards our financial aid system, which continues to be in full effect as this pandemic continues to persist.
But as you said, they're not asking us to order any of that. They're just asking us to have the box ticked. What happens after that will happen. So what's the practical effect?
With respect, Justice, it is our understanding, based on our friend's submissions here today, that it is not only that they want the collection of data, but also for targeted interventions for Black Canadians. And it is in this sense that we believe the minister's resources are better allocated to providing targeted interventions for the most vulnerable, rather than the intermediary step of collecting race-based data.
But you heard the submission this morning, today, where they said that simply hope that the minister does the right thing. All they're asking this court to order is tick the box.
Justice, with respect, I would disagree that our friend's position is that solely they want the collection of data, as they have mentioned that they would also like targeted health interventions, and it is more at the application and analysis stage of this data collection, where certainly resources would either have to be reallocated and pulled from other initiatives, or any extra resources that currently exist should be going towards that frontline fight in order to protect the health of Canadians, which is the minister's main objective.
So racialized communities aren't entitled to the allocation of resources?
No, Justice. Racialized Canadians certainly are entitled to the allocation of resources, but as my co-counsel has pointed out, the minister's approach specifically targets those who are particularly vulnerable in a variety of different ways. And it is in this way that racialized Canadians may still be experiencing those benefits of, or are experiencing the benefits of, the government's response through the way in which they have targeted those who are particularly vulnerable, either in their health or in their financial situations. Justices, as I see that I'm almost out of time, if I may have just an additional 3 minutes to briefly touch on our Doré analysis and then conclude the respondent submissions. Thank you, Justices. I would like to now draw your attention to our final submission at paragraph 73 of the respondent's factum. While we agree with the Supreme Court of Canada's decision in upholding the minister's approach, we disagree with the test that they used to get there. This is not an appropriate situation to impose a Section 1 traditional Oakes analysis, because this court is tasked with determining whether an administrative decision maker exercised her authority in accordance with the charter. And in this way, an administrative law review, which on the standard of reasonableness, is more appropriate. And this approach would ask whether the minister unreasonably limited the appellant's rights. We acknowledge the minister's approach must be minimally impairing, in that it must not impair the appellant's approach more than is necessary to achieve the statutory objective of promoting and preserving the health of Canadians. The minister's approach is minimally impairing as the dissemination of medically irrelevant data fails to appropriately inform individuals or Canadians more specifically about the relevant risk factors. Additionally, the collection of data could lead to surveillance and privacy concerns, as well as potentially further inciting incidences of discrimination in our society, and evidence of these likelihood or the likelihood of these further infringements, if this data was disseminated, is evidence that the minister's approach was minimally impairing. Finally, there must be proportionality between the approach to data collection and the statutory objectives. And it is our position that because there has been no evidence which suggests that the collection of race-based health data would alleviate the risk or spread of COVID-19, that the minister's response, which has allowed for a more effective allocation of resources, does support her statutory objective of promoting and preserving the health of Canadians. It also works to prevent further breaches of privacy, potential further incidents of racism, and ensuring that Canadians have the most relevant medical data in order to make informed health choices. It is for these two reasons, Justices, and under an administrative law Doré approach, that we would submit that the minister's decision, if a charter breach has been found by this court, was reasonable and as such should be upheld. Justices, this was not a case in which the respondent fueled systemic racism. While Black Canadians may be disproportionately affected by COVID-19, it is not their race which is the cause of these disproportionate effects. Collecting race-based data would not only not alleviate these disproportionate effects, but it would require a reallocation of resources, which could lead to more detrimental effects in the future. This case today has centered around whether the appellant's charter rights—
Counsel, let's wrap up now. Can you summarize the rest of the conclusion?
Absolutely. Our position is that Section 7 of the Charter, as well as Section 15 of the Charter, have not been violated, and alternatively, if a charter breach is found, it should be upheld as reasonable under a Doré administrative law approach. Barring any further questions, Justices, these are the respondent submissions. We respectfully request that you dismiss this appeal and uphold the order of the Supreme Court of Canada. Thank you.
Thank you. Reply?
Yes, Justice. We'll like to reply to 2 points made by our friends. One, the data collected that we're asking for would be for COVID generally, not just at the vaccination point. And two, we're just asking the court for a declaration, not an order against for targeted interventions. Thank you.
Justice Bernstein?
I have a question. The respondent suggests that the appropriate Section 1 analysis should be conducted and should be governed by Doré, not by Oakes. And I wanted to know what you thought about that.
Yes, Justice, absolutely. We govern this analysis under Oakes because we noted that that is what the Supreme Court applied in the lower decision and also in a similar case, PHS. However, we would like to briefly note that even under the Doré analysis, it would fail under Section 1 because the minister's response does not meet an appropriate balance between the charter values of substantive equality and principles of fundamental justice and the decision maker's statutory objectives, which is to protect the health of Canadians, which necessarily includes Black Canadians from COVID.
And Oakes is largely a criminal law case, but PHS is not. Do you see there as being a substantial difference between the Doré test and the Oakes test? The respondent seems to suggest that Doré has a more flexible or perhaps lower standard.
I see that my time is up. If I could just briefly respond to your question. Sure. I see that we understand that Doré has greater discretion for the administrative decision maker. However, even with this discretion, it must be constitutional and it must meet an appropriate balance. And doing absolutely nothing in this case to respond to the disparate health of Black Canadians does not meet an appropriate balance. It's doing nothing.
Okay, thank you.
Thank you, Justices.
Thank you. Counsel, thank you for your submissions. Much appreciated. We will reserve our decision on this matter.
Thank you, Justices.